Hey everybody, John Skiba here, and in this video I'm going to share some tricks of the trade. I had a trial this morning against one of the larger debt buyers, and I thought, there's a few things I do when I'm in trial that I thought it'd be good to share with you that I do over and over again because I found them to be highly effective. But if this is your first time here to my YouTube channel, please click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, so I was in trial this morning against one of the big junk debt buyers here in one of the local justice courts in Arizona. It's still kind of weird now. They actually did the trial via telephone, which was kind of interesting, particularly because I think opposing counsel was in his car. You could hear the signal, the turn signal clicking as it going along, and I thought, I guess that's how the world is now. What used to be kind of a more formal process is now we're just doing it from our cars as we go down the highway. So, but as I thought about it, there's a few things that this trial may turn on, and we didn't get a ruling yet. The judge took it under advisement, meaning the judge wants to think about it more and then issue a written ruling. But a couple things that I do in each and every trial or arbitration hearing, I thought would be good to share with you. I actually have picked 3 of them that I'm going to talk about today, and this comes from doing this for I've been an attorney almost 20 years. I think I've done about 400 trials, arbitration, so I've done quite a few. So the first thing, tip number 1, is to pay attention to the details. Now, in this particular trial I did today, I can tell you when I'm preparing for trial or I'm looking at summary judgment, as far as responding to a motion for summary judgment, I go through their documents line by line. I want to make sure I know those documents frontwards and backwards. I want to look for any discrepancies in the documents. Now, in the trial I had today, there was an affidavit they had submitted from the original creditor, and the affidavit is like a sworn statement, and the statement is signed. And as typical with most affidavits, there is something in the bottom called a jurat, which is where a notary stamped it saying, so-and-so signed this document, and, yada, yada, yada. The purpose, by the way, of a notary is the notary public, their job is to verify who the person is who's signing that document. Doesn't mean that all the information in the document is true, but their job is to say, if John Skiba is signing a document, that John was there, showed ID, and that's who actually signed this document so that there's no question. Well, if you look at this document, and here, let me throw one up on the screen for you. What was interesting about this is this affidavit was signed by someone from Synchrony Bank named Nikolai Nasrabadi. I probably messed that up, so I apologize to Nikolai there. But if we look at the jurat below it, the area where the notary public signs, it says, signed and sworn to me before this 14th day of September 2015 by Anthony Davis. Hold up, Nikolai is the one that signed this, not Anthony Davis. And I've seen this before. I've seen it even more egregious. I've seen it where the beginning of the affidavit states one person is attesting to it and then it's signed by somebody totally different. Well, in this case, it looks like they've messed up their notary area, and they've actually put down that it's the notary that's signing it. So you may ask yourself, okay, who cares? The reason why this is important and why it can play a big role in your case is because things like this, when you point them out to the court, whether it be in a response to summary judgment or on cross-examination at a trial or an arbitration, is that it breeds some distrust for their documents. In the legal world, this is a pretty big mistake. It's one of these things where someone's not paying attention to details, or even on the, maybe on the other end of the scale, they're just committing flat-out fraud. Anyways, it makes the court feel a little bit less, trusting of the information that the debt buyer is providing. So know those documents inside and out. Look at it very closely. Look at dates. Look at amounts owed. Look at addresses. All that kind of stuff, and make sure that it lines up correctly. All right, the second thing that I want to talk about, these last 2 are more cross-examination things, but they could be also used when you are submitting a response to summary judgment in response to an affidavit by a junk debt buyer. When I cross-examine junk debt buyer witnesses, they're usually these custodians of records, and they bring them in and they try to use them as kind of a jack of all trades, but they're really only supposed to be there to try to authenticate the documents that come in. The first question that I always ask them on cross-examination is I always ask them, okay, your attorney's gone over all these documents that the debt buyer is trying to admit into evidence. They've just gone over all of these documents with you. Can you tell me, have you ever seen these documents before? And they'll always say yes. And I'll always say, okay, tell me, when did you first review these documents? And so, like this trial that I had today, this case has been pending for over 3 years. The wheels of justice move slowly, particularly in COVID. This witness said that the first time he had viewed these documents was last Friday, about 4 days ago. So, and I said, okay, so the case has been pending for this time, and the first time you've had any contact with this is, just last week. I've even said in trial and in arbitration before, I'm like, Judge, you, I, opposing counsel, we all have more experience with these documents than the person that they brought in to testify as to their accuracy. And so I really pound that in that, hey, they don't know what they're doing. But that's my one tip, is to ask them when they first became aware of this account or this case that they're testifying about, and you'll be surprised that it was usually, it's usually the morning of. I guess I should give this witness some credit, because the witness I had today at least looked at it a few days ago. Often, it's just right before the trial starts. So that's my second tip, is to really ask them when they became aware of the account. Second tip on cross-examination, and again, this can be done with summary judgment, is I ask them what their training is. Because the debt buyer is always in this situation where they're going to have a witness come in and testify on behalf of other companies. So at least they're going to try. And so, like the case I had today, the debt buyer was Midland Funding, the underlying creditor was GE Capital, Synchrony Bank, and all this kind of thing. I'll always ask them, have you been trained on how Synchrony Bank keeps and maintains its business records? And sometimes I'll even be a little more nuanced. I'll say, has Synchrony Bank ever trained you on how they keep and maintain their business records? Has Wells Fargo ever trained you on how they keep and maintain their business records? The reason why I want the question, twofold. One, I want to know, and I want to point out to the court, they don't have any idea what they're talking about. When they say that the original creditor kept and maintained the records in the ordinary course of business and all these things, they have to meet the business records, the business records exception to the hearsay rule. They kind of paired all these things, Rule 8036. I know I'm throwing a ton of detail, but if you're kind of in the minutia of it, you'll get that. But I bring that up to show that they really don't have any idea what they're talking about. And then I frame it in such a way, I don't say, have you received training on how Wells Fargo keeps and maintains their business records? Because a lot of times they'll say, oh yeah, my boss did. My Midland Funding, they provided me a worksheet on it. I don't want that question to come out. So I will frame it, has Wells Fargo provided you any training? Has Synchrony Bank provided you any training? Because they never have. They're not going to come in and train Midland Funding or portfolio recovery or Unifund employees. It's just not going to happen. So that's my third tip. First one is to know the documents forward and backwards, read every line, compare account numbers, compare balances, compare addresses, compare all of that stuff to make sure that it's all lining up, and any discrepancies you can take advantage of by pointing out to the court. Second thing is, on cross-examination, or if you are submitting something in response to an affidavit, it's usually cross-examination though, ask the witness when the first time they became aware of this account was. You want to know the exact date, and I promise you it was either that day or just a few days prior. And then the third and the final thing that you want to do in connection with this, you want to find out what their training is. You want to find out and get them to confirm to the court that they have not received any training from the original creditor on how the business records are kept. Those three things I do in every single case, and they create some doubt, they create some uncomfortableness, if that's a word for the court, some discomfort, there we go, some discomfort for the court as to the type of information that they're actually receiving from the debt buyer, that it may not be that reliable. So hopefully that helps you out with your case. I will put, if you have questions, put them down in the comments. I'll put links to some of the tutorials I've been putting together. You can take a look at those, and I appreciate you watching today.